Welcome back. We're getting on to their application to the court, and we'll go through it step by step so that you can see their side of the story and what they accused me of doing, and then I'll clarify my methods and how I did things as we go through. So, on the evidence list, it's page 6, it states, and I quote, ISS Security has an obligation to maintain confidential information and terms of the services and contracts without intending to waive any confidentiality attaching to the Security Screening Services Agreement with BACL. BACL is Brisbane Airport Corporation. The agreement provides the confidentiality obligation upon whom each party not to disclose information provided by any other party and that is not publicly available, including the existence and contents of any document. Now, that document was actually provided to me as evidence in this Supreme Court hearing. So ISS blatantly made it available to not only me, but to the courts. Had I chose to read it, it would have become an issue. But as I had no interest, we didn't go any further with that. So, whilst they're telling everybody that I was breaching all their confidentiality, here they are, openly, blatantly giving the contract for a third party to read, which has everything to do with their financials, their staffing, their methods, something that I was really not interested in anyhow. So with that at note, you can see how this company clearly had no idea as to, it wasn't so much they had no idea, but I'd had them so stressed about this matter that they were willing to do anything to put me away. Now when I sat in court, the judge stood me up 3 times, telling me to pay attention, this is serious, do I know how serious this is? And it wasn't till the last time I stood up and I actually responded to him by saying, well, for them to make these claims, then I read it somewhere that you would need to have some form of evidence. And the judge said, yes, that's correct. And I responded by telling him then we're in the wrong courtroom, because all my documents were Freedom of Information stamped, and that means the government has released the documents for public viewing. That makes it a constitutional court matter, and therefore we're in the wrong courtroom. At that point it was the time the judge turned and said, maybe I should hear what you've got to say. Now, when you first get to court, there's going to be, we'll get back to this stuff in a minute. When you first get to court, I was up against a guy by the name of Adam Walker from Melbourne, media guru apparently in law, and what he had said to me was, he comes in the courtroom, he says, are you Troy Agate? I said, yes. He goes, get outside. I thought, yes, Dad. No, I went outside. He said, you're going to do this, you're going to give us all the documents, you're going to give this, you're going to do this, you're going to give a whole list of stuff that he wanted me to do. And I said to him, I think that would hurt my case if I did that. And he replied by saying, I don't give a fuck about your case. If you go in there, you won't see sunlight for 10 years. Now that man had every opportunity and dream of putting me in jail for 10 years for something I didn't pick, I didn't fight, and I didn't start. Now that originally, whilst I was right there, thought, you're an asshole. That's putting it blunt. So we went into courtroom and they call it short trials. Now a short trial is where you plead guilty. So that means I'm now going to plead guilty all of a sudden. After 4 or 5 years of fighting this, I'm now going to go, I'm guilty, I did it. Mistake number 1. Now he stood up in front of the judge and said, Troy's going to do all the same list he gave me outside, Troy's going to do all this stuff. And the judge looked at me and he went, how about we get Mr. Agate to see a lawyer before we proceed and make sure he understands what he's signing off on. So I put my hand up. I said, excuse me, Your Honour. He said, yes. I said, I have no idea what he's talking about, because that's not the conversation I had with him outside. And he said, well, what did you tell him? I said, after he told me that he was going to take the sunlight away from me for 10 years, I told him to fuck off. And we came back inside. The judge looked at them and said, seems you had a conversation with someone else. See you at long trial. So we came back at long trial, and that means you get to hear your case. 6 hours they went on against me. 6 hours. Now they had a good team. They had a Emma law firm from Melbourne. They had Adam Walker, media guru, and they had 2 guys from Copenhagen. And for 6 hours, they were into me like a dog to a bone. Lied to the courts on a number of occasions, which I pointed out. We'll get to those facts later on. And it wasn't until the judge had stood me up the 3rd time and he wanted to hear from me, after 6 hours, did I get a word. Now, I had 1 page of writing. That's it. That's all I had. And you remember these are absolutely crucial if you're going to defend yourself in court. All you need is date, the date of whatever's happened, the fact, that's the whether it was a complaint, whether it was whatever the issue was. Then you had the issue itself, so just a sentence on the issue. And then you have date, fact, and the time. So keep a diary, and I tell this to all my friends. When you're working for a company, keep a diary, because that diary is submissible as evidence in a court of law. You write anything and everything in that diary that has something to do with work, whether it be seeing someone steal something or having someone do something to you that you find offensive, and write some nice things that happen to you there as well. It's always good. So you need that evidence, and it's very important. And if you haven't kept the diary, start writing notes now of the events that you remember, because you're going to need them, because that is crucial to your case. Now, when I read out that list, I got down to obstruction and hindrance of a Commonwealth official. And then I had one more line to say, and that was it. Now, that one line was enough to spark the judge's interest. And he said to me, who's a Commonwealth official? And at that point, the other side, ISS Security, all jumped up in the air and went, objection. The judge nicely looked at them and told them, you do know it's on file, don't you? And I kid you not, all their mouths were open, looking at me, wondering how the hell I got my documents on file in 3 days to appear at 10 o'clock on the 4th day. We're going to get in, and I'll explain how that happened. So, I answered his question. I said, I was the Commonwealth official. And he said, and what was your role? I said, Australian Federal Police, Advanced First Response to Counter-Terrorism. And position was a PSO. So, from that, he looked up in the air, and then he looked at their table, and he went, oh really? All their faces hit the floor. They were all looking at the floor. No one looked at the judge, because in 6 hours of telling the judge of what a prick I was and how I procured and slandered, defamed, criminally intended, the list was long. I'd done everything apart from rape and murder. So in the 6 hours of their accusations, of their list of criminal activity that I had occurred, not once did they mention my job. and they were hoping the judge would never hear what my job was, because all I did was follow a roster. We'll talk again in the next session. See you in part 4.